Mr. Grindler, we have quite a stir on making sure that the United States follows its own high standards and laws. The Office of Legal Counsel is one that has served very well for both Republican and Democratic administrations when the people who are the professionals and nonpartisan professionals are allowed to operate. When they have indirection or direction of a political nature and respond to that, then the Department of Justice is badly damaged. Department of Justice has to make determinations outside of politics. I recall when I was interviewed as a young law student by the then Attorney General, asking me if I'd come to work for the Department of Justice. I'd asked him, how much political influence would there be in the Department of Justice? The criminal matters, civil rights matters, whatever. He said, I've told the President personally, neither he nor anybody in the staff can interfere with what we're doing on prosecutions. That Attorney General, incidentally, was Robert Kennedy, and he subsequently prosecuted somebody who was vitally important to his brother's election as president. We found during the last administration what raised my concern. We had several hundred people in the White House who were allowed to get involved in prosecution matters. That's not the way this should operate. It's not the way it shouldn't operate that way in any administration. I think of handling terrorists when President Reagan used the FBI to set a trap for a terrorist overseas. Caught him, used their interrogation procedure, brought him back and convicted him. We've seen Zazi, who was convicted just in the last few days in New York. Both the Bush administration and the Obama administration have been pretty effective in prosecuting people who we followed their rights. We have gotten a great deal of information from them, and we've also been able to demonstrate to the rest of the world we follow the rules. That's why when we don't, it is a bad mark. As Senator Durbin indicated, we have these rules because we also want to be able to tell the rest of the world if you capture one of our people, and we know that some will not follow the rules, but we want to be able to have the high moral ground. We don't want to be in a case where we can be lectured on human rights by countries that don't follow it.
Chairman, I have a very important appointment I'm going to need to ask leave. Thank you for your leadership. I leave this Washington Post editorial on the report by Mr. Margolis. And Mr. Deputy Attorney General, congratulations on your service. You've got a tough job, but it's an important job. Use good judgment, keep a cool head, and do right. And I agree with the chairman completely that you've got to make these decisions based on the law and the facts, and we can't allow politics to infect the Justice Department. Thank you.
Thank you, Senator.
Thank you, Senator Sessions. We will keep the record open to the end of the day for statements by senators or memos or torture. In fact, I will also ask that any questions are submitted be answered by this time next week. Let me tell you this, or let me ask you this. The BIVU-OLC memos argue the Commander-in-Chief authority is so broad that in a time of war, even an undeclared war, or saying that we're at war because terrorists want to attack us, and I assume that they always will, my lifetime, the President could take nearly any action in the name of national security. That action would be lawful. In an interview with OPR, Mr. Yu answered affirmatively when asked if the President could order a village of resistance to be massacred. Mr. Hughes that said such an order would fall within the Commander-in-Chief's power over tactical decisions. Can you imagine how we would react if we heard the head of another country's government make such an order? There would be total outrage expressed by people from the right to the left in this country. So let me ask you, what is the current OLC interpretation of the Commander-in-Chief authority? Has OLC articulated a formal interpretation since the Obama administration took office?
Senator, if you're talking in terms of interrogation authority, is that the question?
No, I'm talking about what is the Commander-in-Chief's authority? Is it basically, as Mr. Hughes seems to indicate, virtually without bounds, because we know that we will face and probably always continue to face attempts by terrorists against the United States?
I believe that some of the memoranda prepared by Mr. Yu, Mr. Bybee, did, as you pointed out, address what the president's power may be in certain circumstances. I'm not aware of OLC having rendered any opinions since the president had indicated that the opinions post 9/11 were no longer to be relied upon. But to give you a definitive view, I will go back to OLC and provide that information to you. But I'm not aware that they have issued any opinions since President Obama came into office.
Well, the reason I asked this, in January 2008, the then Attorney General Michael McCasey sent a letter to this committee, and he said that waterboarding might be reintroduced under the defined process by which any new method is proposed for authorization in the CIA's interrogation program. Sort of a complicated way of saying that the CIA or the White House asked again whether the Department of Justice might find waterboarding to be legal. The Obama administration, as you said, issued an executive order limiting interrogation techniques of the Army Field Manual. They did that in January 22nd of last year, which basically outlaws waterboarding because the Army Field Manual does. But this administration, at the most, will hold office for 7 more years, either 3 more years or 7 more years. But some prominent Republicans, including candidates for elective office, have outright endorsed waterboarding, or they refuse to condemn it. So that other than that January 22nd executive order, is there any authority in force today to prevent either this administration from changing its mind or a subsequent administration from approving waterboarding as legal interrogation technique? Notwithstanding the fact that we have in the past prosecuted people who have used waterboarding.
Senator, again, the President of the United States has made clear that torture will not be condoned and that any interrogation must be consistent with the Army Field Manual. Again, with respect to OLC, which does have the responsibility as delegated to them by the Attorney General to provide advice to the President on legal matters, I'm not aware that they have issued another opinion since this President came into office on interrogation or even the broader powers of the President in these circumstances. I will confirm that, but I think that's about all I could say right now.